LLP partner exits. This is an area where many of the rules of the game on senior executive terminations or senior job moves either don't apply or they don't apply in the usual way. So you really need to understand the specific rules that apply to LLP partners in order to be able to do this properly. With that in mind, here are my top tips on LLP partner exits. Remember that LLPs in many ways are not like traditional partnerships. Yes, they combine some features of the traditional partnership, but in other ways they're more like limited companies. They are corporate vehicles. When it comes to LLP partner exits, the terms of the LLP agreement are absolutely crucial. It's worth thinking of LLP partners, who are strictly speaking called members, as being a bit like the members of a club, with the LLP agreement setting out the rules of the club. So if you're in a partnership exit situation, you need to check the LLP agreement very carefully and follow the rules of the game in it. One issue we've sometimes encountered in practice is contractual documents that on the face of it provide for dual status, both as partner and as employee. Now, when LLPs were created at the turn of the century, there was originally some confusion whether you could be an LLP member, partner, as well as an employee of the firm. After all, LLPs are corporate vehicles, and in a limited company situation, a company can employ its directors and shareholders, so why shouldn't an LLP be able to employ its members? Case law, however, has clarified that you cannot be both a partner and an employee. You're either one or the other, and if you come across contractual documents that seem to provide for both statuses, you have to look beyond the job title, look very carefully at the contractual documents, and also understand the working relationship in practice to determine the true status of the individual. Now, assuming that you really are an LLP member, then likely under the LLP agreement, the firm will have a power to terminate immediately without notice, which is typically referred to as a power of expulsion, and that will apply where the partner is in serious breach of their duties under the LLP agreement. In that situation, the partner can, of course, challenge their termination and argue that they were not, in fact, in serious breach at all. In practice, firms often prefer to avoid debate or dispute around whether a partner has been in serious breach of their duties, justifying expulsion without notice. So they therefore often prefer to rely on a power under the LLP agreement that gives them the right to retire, as it's called, the partner under a compulsory retirement provision with a longer notice period. 6 months is fairly typical, and often during the notice period the partner would then be put on garden leave. Sometimes the rules of the club will require a partnership vote in favour of compulsory retirement, say with a 75% vote in favour, but often compulsory retirement decisions are just a matter for the management board or the executive committee, so a small group of individuals, but then you will typically have a right of internal appeal afterwards, say to some special committee, or even a vote of the full partnership. What if the partner feels unfairly treated? Well, partners can't claim unfair dismissal, and they can't claim constructive dismissal either. Those are rights that only apply to employees. And I find this often comes as a surprise to some partners, because they might think, given their seniority, given their commitment to the firm, their capital investment in the firm, that they would have greater protection against unfair treatment, arbitrary treatment, when in fact they find that the employees of the firm have greater protection in that regard. As I mentioned, there will usually be a right of internal appeal against compulsory retirement, but that's fine as far as it goes. After all, how often will a special committee overturn a decision that's already been made by the management board, the managing partner, or whatever? Not that often in practice. Of course, in many cases, there'll be a sensible negotiated exit deal. And in other cases, partners will bring employment tribunal claims. They can bring discrimination claims. They can also bring whistleblowing claims. And partner discrimination claims aren't as uncommon as you might think. After all, with the full range of protected characteristics under the Equality Act applicable to partners, there are quite a few discrimination disputes out there. Of course, in many cases, firms are not that diverse at senior partner level, and so quite a few partners complain of discrimination during the process. I guess the types that we come across most commonly would be age, gender, pregnancy, disability, and race. And my final tip on partner exits is always to be very careful if you're planning on joining a competitor and perhaps taking your team with you, taking clients with you, and so on. The fact of the situation is that as a partner you'll be subject to a whole range of strict legal duties: duty of confidentiality, a duty of disclosure, of good faith, You'll almost certainly also have to contend with restrictive covenants, non-compete clauses. Those clauses are more strictly enforced against partners than they are against ordinary employees. So the risk in that situation is relatively high. If you find yourself falling foul of the law, then there's a range of potential problems. You could have to repay or forfeit your profit share entitlement. You might even have difficulties recovering your capital investment in the firm. So always tread carefully and take advice.